Imagine a society in which the law treats people differently merely because of their social status, wealth, caste, or political position. Imagine a country where powerful individuals are above the law and ordinary citizens have no legal protection. The framers of the Constitution wanted to prevent such a society, and therefore they placed Article 14 at the heart of right to equality. Hello everyone, my name is Rajni Jha. Welcome to Drishti IAS. In today's session, we will talk about Article 14. Let's get started. Article 14 says, the state shall not deny to any person equality before the law and equal protection of the laws within territory of India. The important phrase here is any person. That means it is applicable not just to Indian citizens, but also to foreigners and legal persons such as companies, corporations, or registered societies. Now, this article has two dimensions, two components to it. First is equality before law, and the second is equal protection of the laws. Let's talk about equality before the law first. Equality before the law has been borrowed from British Constitution, and it is based on A.V. Dicey's concept of rule of law. Equality before the law is a negative concept because it stops states, or it prevents state from giving any arbitrary privilege to anyone. So it stops inequality in society, unequal privileges. That is why it is a negative concept. When we talk about equal protection of the laws, it has been borrowed from the 14th Amendment of the US Constitution, and it is a positive concept. That means it gives state power to ensure equal opportunities in society. So it brings equal opportunity in society. That is why it is a positive concept. And there it stops something. So it stops the state from giving any unequal or arbitrary treatment in the eyes of law. That is why it is a negative concept. So equality before law, it says nobody is above the law. So there's a sense of no in it. That is why it is a negative concept, right? Nobody is above the law. Everybody is equal in the eyes of law. And everyone, regardless of rank or status, is subject to ordinary law of the land. Every individual is equally accountable before the court. So basically, it says no one is above the law, right? For example, whether you are a minister or a prime minister, if you have committed a criminal offense, you will be treated to the same criminal laws as that of an ordinary citizen. Now here there is another concept of rule of law. Now what is that? In rule of law, A.V. Dicey gave three principles. So there were three principles given by A.V. Dicey in rule of law. First is absence of any arbitrary power. Nobody is going to have any arbitrary power, right? Second is equality before the law. So in eyes of law, everybody is equal. So first is absence of arbitrary power, second equality before the law, and there is a third principle also here, which is primacy of individual rights. Now see, in Indian Constitution, in India, we follow the first two. The first two are easily applicable here. But the third part, that is primacy of individual rights, is not applicable in India, in Indian Constitution. Why? First two are pretty simple, right? There will not be any arbitrary law, and here everybody is equal in the eyes of law. So first two are applicable here also. But the third, that says primacy of individual right, what does that mean? A.V. Dicey, he meant that when we talk about individual rights in Britain, it does not come from Constitution, because Britain does not have the concept of a single document called Constitution. So there the rights were a result of court decisions or customs or ordinary laws made by Parliament. But in India, we have a constitution. We have a written constitution, and most of our rights are explicitly mentioned in the Constitution. Because in A.V. Dicey's concept of primacy of individual rights, rights meant the rights that were given by court orders or customs or Parliament. But in India, it's not like that. In India, rights are a result of Constitution. That is why the third point is not applicable in India, but the first two are applicable in India as well. Now let's come to equal protection of laws. As I told you, this means that the state will make positive efforts to ensure equal opportunity, to ensure fair chances of succeeding, of everyone succeeding. Now this, what does it mean? This means that people should be treated equally, yes, but people in the similar circumstances will be treated equally. Like should be treated alike. There what we said, nobody will be treated, nobody will have special privilege. That's what we said here. But here we are saying some people can be treated differently if they are differently placed, if they are in different circumstances. For example, let's say in an examination, every student gets 3 hours to write the answer, right? But there are some students, let's say somebody is physically disadvantaged. in that case, will that student get only 3 hours to write? They may require some extra time. If you give extra time to that student, would you say that this is against equality? Of course not. Why? Because the students who do not have any physical disability and students who have a physical disability, they come from different groups, right? They have different requirements. So when we talk about equality, this means like should be treated alike. If there are different groups in differently placed situation, there can be different treatment. That's what the second part talks about, and that is why affirmative action is required. Just like in that case of that student, if a differently abled student is there, the student might need extra help or extra time, so that there is a fair opportunity for him also to express how much he knows, to express his knowledge, right? And with that logic, we come up with reservation for SCs, STs or OBCs. They are not unconstitutional. This is constitutional because they have been historically disadvantaged. Now, but here the point is, does Article 14 prohibit all kinds of classification? I just told you, no, classification is allowed. It only prohibits class legislation. What does it mean? Class legislation means that you're treating somebody arbitrarily without any rational, without any reason, without any reasonable basis. So you're giving somebody special privileges without any reasonable basis. You're discriminating against anyone without any reasonable basis. That is class legislation, and that is not allowed. But reasonable classification is allowed. Now, what is that? If you have a reason for treating somebody differently, then you can do that, like we saw in the case of student, the differently abled student. But if that is the case, I can come up with a reason for anyone. How would we check it? To check reasonable classification, there are 2 tests, and both the tests should be satisfied. The first test is intelligible differentia. How would you remember it? Differentia, you are making differentiation, so there are different groups, and the reason has to be intelligent. You can remember it like that. So here we are talking about the classification, but that there should be a reasonable basis for distinguishing 2 groups. For example, the reasonable basis in our example was that the student was differently abled. There was physical disadvantage in that case, and that was the basis. Second is rational nexus. Nexus is a connection. Rational nexus means there has to be a connection between the objective of the law and the basis of the classification. What does that mean? Now, let's see the same example. First, the classification was physical disability, right? Physical disability. We made a classification based on physical disability, that there was one group of students who have physical disability and the other group of students who do not have physical disability. Now, how would we check rational nexus? For that, we need 2 things. First, what is the policy that you made? The policy that I made was the students with physical disability will get extra time, right? This was the policy that I made, for example. What is the goal I'm trying to achieve? The goal is that everybody gets fair chance. Everybody gets fair chance to express what they know, to show their knowledge. Now, rational nexus would mean that this basis that you created for classification and this goal, that should be equal, that should be connected to each other because of this policy. So ask yourself the question, the policy that you made, is it ensuring the goal? Yes, it is ensuring the goal. The classification was, there are 2 set of students, one is with physical disability, other is without physical disability. The goal is fair chance to everyone to express what they know. So I made a policy to give extra chance, extra time to the students with physical disability. So yes, it is meeting the goal. That's what rational nexus is. First, the classification should have a reasonable basis. Second, there should be a connection between what classification you made and the goal you're trying to achieve. The same goes for the reservations also. Reservation policy of SCs, STs or EWS. The classification is that these groups have been historically disadvantaged, discriminated against. So there was a group that was disadvantaged. There was a group that is not disadvantaged, right? So that is the basis of classification. Now, what is the goal I'm trying to achieve? To give fair opportunity for everyone to grow. So if I give reservation, will that give them also a fair chance to grow? Yes, that will. So there is rational nexus also, and that is how reservation is constitutional. Next, so we have already seen this. Equality before law is a negative concept because it restricts the state from conferring any special privileges. Equal protection of laws is a positive concept because it requires the state to take positive measures to ensure equality. Equality before law means no person is above the law, there will not be any special privileges for anyone, and there will not be any arbitrary discrimination or special treatment. Whereas in equal protection of laws, it means like should be treated alike, people placed in similar circumstances should be treated similarly, and in different circumstances should be treated differently. This is called substantive equality. Because normally we think equality means identical treatment. Everybody should get same treatment. No, that is not equality. When we talk about equality in Constitution, we talk about substantive equality. Next, equality before the law is based on A.V. Dicey's concept of rule of law, and equal protection of laws is based on 14th Amendment of the Constitution, US Constitution. Here, equality before law does not give any privileges to any class of people. Here, it permits reasonable classification and ensures that there affirmative action so that fair chance or opportunity can be given to everyone in society. Example of this would be whether you are a minister or prime minister, you will be subjected to the same criminal laws if you have committed the offense. And here the example would be reservation of SCs, STs, OBCs to promote equality. Now, are there any exceptions to this? Yes, there are some exceptions. First, presidents and governors, if you're talking about criminal proceedings, they have immunity. If you're talking about civil proceedings, in that case also they should be given prior notice, 2 months notice before these proceedings start. Next is parliamentary and legislative privileges. Members of parliament and state legislation also enjoy certain privileges about their speeches and votes while they are working, right, inside the house. Then there is diplomatic immunity. Foreign diplomats and ambassadors also enjoy immunity from international laws. Now we are at the last part of our session and I have a question for you. The question says, consider the following statements regarding Article 14 of the Constitution of India. First, Article 14 guarantees rights only to citizens of India. Second, the concept of equality before the law has been borrowed from British Constitution. Third, the concept of equal protection of laws has been borrowed from the Constitution of the US. And fourth, Article 14 prohibits all forms of classification by the state. You have to tell me which of these is correct. And that is your homework. So I hope the concept is clear to all of you. If you have any questions, you can drop them down in the comment section below. That's it for today's session. Thank you so much for joining in. I'll see you again. Until then, take care.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.